patent, patent, it looks like a article. So research article, whatever article you are preparing for the publication in the Scopus or Web of Science index journals. So like that, we need to prepare the patent also. End of the publication or research article, you need to write some claims. Okay, so this claims part is additionally we need to write for the patent. Okay, so this is brief information I would like to give, because we have some experience and knowledge about this filing the patents, because from our college so far 38 patents are published. 38 patents are published and 2 patents are granted so far, 2 patents. So that is why we have some experience in this intellectual property rights filing, publication and patent, granting of the patent. So that is why this knowledge has to be exchanged from one college to another college, one faculty to another faculty. In this context, we are coming forward and motivating other faculty also to come forward and going for these publications and a grant of the patents. So after granting of the patent, we can go for through this product formulation or any medical device or any apps, whatever maybe it is, through this. So we can go for our own establishment like startups or entrepreneurships like that. Okay, this is one area to be focused in this IPR. Another one is what is the benefit of this IPR? So benefit already just now I told. So we can establish our own this one business like that, and this publication you will be identified who what work you have carried out and what is the importance of this one. It is going to be beneficial to the society also. Okay, so one more thing, when you publish the patent, when you got the patent, it is definitely helpful and useful to the college in terms of accreditations, in terms of rankings of the college. So that is why we need to definitely being a faculty member, this has to be transformed to one to other, right? So in this brief introduction, I request both the colleges should have the contact of carrying out the research and like novel thoughts and ideas sharing each other like that. Okay, so I thank for giving me this great opportunity by IAC coordinator Satyashree Madam from VV Institute of Pharmaceutical Sciences, and Nirmala College Pharmacy IAC coordinator Dr. Anjana Madam, and today's organizing secretary Dr. Pamal Reddy sir. So thank you all for giving me this great opportunity. Thank you, Anand.
Thank you, sir. Thank you for your valuable information. Now we'll request our IAC coordinator, Dr. Anjana Madam, to speak few words about this.
Thank you, sir. Thank you, Pamal Reddy sir. Am I audible, sir?
Yes, madam.
Yeah, good afternoon to respected Principal Sir, Dr. Sheikh Abdul Rahman Sir, and Dr. Lakshman Sir, Principal of VVIPS, Dr. Pamal Reddy Sir, and Satyashree Madam, VVIPS Coordinator. Myself, Dr. Anjana, Coordinator of Nirmala Innovation and Incubation Center, Nirmala College of Pharmacy. It's my privilege to introduce about the Nirmala Innovation and Incubation Center to the students and staff of the VVIPS. Our NISC has been started in the academic year 2018 and 19, and from past 3 years, we are carrying out various activities driven by the IAC and MIC. So in this regard, we have carried out innovation programs, entrepreneurship programs, such as NIPM and pharmacovention. Recently, we have carried out. Related to this, we are acting as a mentor for 2 organizations. One is to the Nirmala College of Pharmacy at Kerala, and another one is the VVIPS. Our NISC has been ranked to 3.5 rating by the IAC of the AICTE. So for the development of any institution, first step is the research, in which segments like publications, patents, research grants, books, and book chapter writings, all these are the core segments. So in this context, we are finding our college from past 5 years, we have done 180 publications in various Scopus and Web of Science Index journals, filed 43 patent applications. Out of that, 38 has been published and 2 of the patents have been granted. And we have received 89 lakhs of grants from various government and non-government organizations in the past 5 years. We have been participating in the various IAC-driven activities carried out by the Ministry of Education. And it's our pleasure to act as a mentor for the VVIPS in this regard. We would like to extend our cooperation in mentoring the VVIPS. Today, we are carrying out the first session, that is the guest lecture on the importance of IPR in the research. So related to this IPR in research, a detailed scientific information will be provided by our faculty members, Mrs. Srikala Madam and Dr. Shreya Madam. A brief introduction related to the resource persons. Mrs. Srikala Madam, she has got 6 years of teaching experience and she has published a good number of publications and she has got industrial experience also. And Dr. Shreya Madam, she is also having the she also received a grant recently, Atal grant. And I would like to welcome both the madams for giving the information related to the IPR in research. Thank you.
Thank you so much, ma'am, for your nice introduction. Good afternoon to all. Myself, Srikala, Assistant Professor, Nirmala College of Pharmacy. Today, I would like to discuss about IPR, intellectual property rights, and the importance of IPR in research. Sorry for the interruption. Sorry for the interruption. Intellectual property rights. It's a property that derives from the word of the mind or intellect. It arises from human creative ideas and expressions of mind like poems, stories, drawings, photography, design, logo, and mobile apps, etc. We can define IPR. It's a legal right given to the persons for their intellectuality for a certain period of time. It's a strong tool to protect persons' investment in the form of time, money, effort to invent in his inventions or to create literary works, symbols, images, etc. If you create a product or publish a book or find a new drug, IPR ensures that you benefit from your work. Now, let us see the inventor cycle. First of all, it starts with imagination. This envision, what does it is exist? It leads to creativity. This applying imagination to address a challenge. Afterwards, this creativity leads to the innovation, applying creativity to generate unique solutions. This innovation leads to entrepreneurship, applying this innovation uses for addressing a challenge. Intellectual property rights can be applied by any student or any faculty member, any person or any institution or group of students and group of faculty members, any startup or any company. Intellectual property offers so many benefits to the students or student members or faculty. It can give so many awards and rewards, and it will give a lot of recognition to that particular person. We can earn money as a royalty or incentives, etc., through technology transfer and licensing. We can commercially market our product without any fear of copying. And genuine and original products can produce like medicines, vaccines, and all. It leads to new innovations, new markets, and new business. It increases the value of college, faculty members, students. Finally, it builds our country with strong and modern economy. Now, let us see where we are in intellectual property rights usage. See here in the graphical representation where we are in 7.1%. Even though we are having a lot of manpower and machine power, without having proper awareness about IPR, we are having at least, this is due to lack of awareness. So we should aware people in order to use this IPR for increasing our economy. Now, let us see what is the need to promote and protect IPR in order to invent new works in the areas of technology and culture, and to create public awareness about the benefits of IPR among all sections of society, thereby creating strong economy, and to stimulate the creations and growth of intellectual property by undertaking relevant motivational measures. Now, let us see the difference between common man and businessman. Common man is even though he is having pride and academics, when compared to businessman, he is having extra IP protection, that means intellectual property protections, and he can commercialize the product, and he can have his own brand value. Thereby, he can earn or invest and reinvest. Thereby, he can lead good and successful life. Now, we can have a lot of intellectual properties. Some of them are patent, design, trademark, copyright, geographical indications, and semiconductor integrated circuits layout design, trade secret. These are all the important intellectual property rights we have had. Let us explain patent. It is an exclusive right granted by government to a person for protecting his own invention from others' uses in terms of making, using, exercising, vending, and importing. It is a qualified right to use the invention for the period of 20 years from the date of filing. It's a monopoly right. Here, we should remember one thing. After the grant of patent, it should be renewable, and it is a vital step that it is renewed regularly and unceasingly. This can be done by payment of patent renewal fees diligently during the lifetime of the patent, that is 20 years. Now, see some of the examples. Recently, we are getting patents in India. First one is baby head bath cap. By using this head bath cap, that water won't come to the eyes, thereby it will protect baby. And next one is laptop. Afterwards, this one, freestanding cricket wickets. And next one is mobile swiping card. Next one is light cap. And the last one is hangers. We can fold when it is not in use. This is the difference between research paper and patent. What is research paper and what is patent? What's the main difference between these two? Research paper, usually we submitted it to the general, but the patent is submitted to the patent office. Research paper, it is a technical document, whereas patent is techno-legal document. We are going to prepare manuscript in case of research paper. In patent, we are going to write different specifications, that is provisional application and complete application. Research paper can be prepared by using literature reviews and literature surveys, etc. But if you want to file a patent, you're going to see, or you're going to get information from prior art, state of the art, and related art like that. And research paper, we can get review from the editors. And in case of patent, after submitting our patent application, we can go for examination. And by publishing research paper, we can get citations. Here we can get our document. And finally, in research paper, our paper will be published in a reputed journal. In case of patent, we are going to get exclusive legal right for about 20 years. Then let us move on to the next topic of IPR, that is design. Normally, we can define design as it includes various features like shape, configuration, different patterns, ornaments, and different type of articles, whether in 2-dimensional, 3-dimensional, or in both forms. By any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which is in the finished article appeal are to judged by the eye. The monopoly right of this design is about 10 years and it can be extended by 5 years. Here you can see different type of designs. And these are also some of the designs which will be useful for us. Different type of fabric materials and laptop bag and Kolhapuri chappals and different type of pens and bristles, toothbrush bristles and credit card purses. These are all different type of designs. We can get, this is coming under design category of IPR. And the next one is trademark. Trademark, it is a sign capable of distinguishing the goods or services of one enterprise from the other enterprise. By seeing the trademark, we can distinguish what that it is actually. It is valid for 10 years from the date of application and it is renewed indefinitely as long as the renewal fees are paid every 10 years. You can see some of the trademarks here like McDonald's, Blue Dart, Adidas, FedEx and our India Post and all. In this trademark, we can include either brand name or any tagline or sound mark or logo. If you see the different taglines, for example, if you're taking Nike means just do it. That is the slogan line. So trademark, it contains slogans, images or any symbols like that. LG means life's good and Coca-Cola means hope and happiness like that. There are so many trademarks with the slogans and sound marks. This can be registered by either that particular product having TM at above that particular slogan or image or any registered mark or symbol will be there at the top right of that particular slogan or image. And the fourth IPR is copyright. This copyright, what it is? This is the right given by the law to an author or composer to print, publish, sell copies of his original work. This may be a literary work or musical work or an artistic work, a cinematographic film, a sound recording, or a photograph. These are all coming under copyrights. We can get copyright for these intellectual works or creative works. This copyright owner has rights to reproduce, translate, adapt, perform, distribute, and publicly display the work, etc. This registration is not mandatory since copyright comes into existence as soon as the intellectual work is created. It is recommended to register a copyright for better enforceability since registered copyrights have evidentiary value in court of law and the symbol of copyright is T. So here you can see different type of copyrights, literary or dramatic or musical or artistic work. For that, the lifetime is about 60 years from the death of the author. Lifetime of the author and until 60 years of author, the lifetime will be. For literary, dramatic, and musical works. For anonymous or pseudo-anonymous works, the lifetime will be 60 years from the year the work was the first published. Okay, and then works of public and undertaking and government works, for this also 60 years of lifetime will be there. Works of international organizations, for this also 60 years, and sound recordings, cinematographic films also 60 years from the year in which the film was published or recording was published. And then move on to the next IPR, that is geographical indication. A geographical indication is a sign used on products that have a specific geographical origin and possess qualities or a repetition that are due to the origin of that particular place. For example, if you are taking Tirupati Laddu and Koshampalli Ikat, then Bobbili Veena, Warangal Durries, Hyderabad Halim, Venkatgiri Saris, Darjeeling Tea, these are all we may know by the space where it have. Okay, that is geographical indication. And then move on to the next thing, that is semiconductor integrated circuits layout design registry. In this, these are fabricated from a complex series of layers of semiconductors, metals, and dielectrics. For this also, we can get IPR. Original, distinctive, capable of being distinguishable from any other layout design and have not been commercially exploited anywhere else. And move on to the last one, that is trade secret. It is any practice or a process of a company that is generally not known outside of the company. Trade secret, the name itself indicates what is the formula included in that particular product is not known by the other people. This information considered a trade secret gives the company an economic advantage over its competitors and is often a product of internal research and development. Here, we are going to get an agreement of confidentiality. For example, if you are taking Google search algorithm have trade secrets. So no one knows that. And KFC fried chicken also. For that formula also is very secret. For Coca-Cola formula and WD-40. This is it's a WD-40 is a blend of lubricants. It is having wide applications in industry. And like that, McDonald's Big Mac special sauce is also having trade secret. Now, see who can apply for this IPR. Persons include firm, partnership, shell entity, and a body corporate. Persons are firms are joint business. Anyone can apply for the IPR or geographical indications. The validity for the patent is 20 years and for design is 10 years plus 5 years and trademark indefinitely. And for copyright, lifetime of the author plus 60 years. And for geographical indication, it is also indefinitely, subject to renewal for every 10 years. All IP rights are territorial in nature. Now, we can see different type of IPS in one product. Intellectual properties are in one product. If you are taking laptop as an example, here the working mechanism, patent is included. In the body of laptop, design is included. And in the Apple sign, trademark is included. And in user manual, it's a symbol of copyright. And in the layout of IC, it is included SICL, that means semiconductor design. Here, patent, where the patent offices are located, in different metropolitan cities, patent offices are located like Kolkata, Delhi, Chennai, and Mumbai. And trademark registries are located in Mumbai, Delhi, Kolkata, Chennai, and Ahmedabad. And design wings are in at Kolkata and geographical indications in Chennai. Copyright office is located at Delhi and semiconductor IC layout design at Delhi and training academy is in Nagpur. Here in this image, you can see different type of offices, patent offices all over India. Intellectual property office in Delhi and in Chennai, Mumbai, and Kolkata. Let us move to the summary of this IPR. It's a property derived from intellect and it has certain rights associated with it. It has a very significant across the globe. It aids the economic development of a country by promoting healthy competition and encouraging industrial development and economic growth. Let us protect our inventions and creations with the help of IPR. Thank you very much for giving me this great opportunity. Now, I'm going to invite my colleague, Dr. Shriya ma'am, for explaining the patent application procedure in India. Thank you. Thank you so much.
Hello, madam.
Sir, one
Hello.
minute. Yes, sir.
Hello. Nikala, madam.
Yes, sir.
Sir? Sir?
Sir. Hello.
Can proceed, madam. Shriya, madam.
Yes, sir. Good afternoon, everyone. And now let's discuss about the patent application procedure in India. Who can apply for the patent? Inventor and applicant. There are two different sections in this application. Inventor is the person who invents the patent, the main idea, brain behind that idea. And applicant might be the person like co-investigator or inventor himself, or sometimes might be the company or any collaboration work. Then they can act as an applicant. Natural person. Natural person means a person, individual or in a group of people can apply for in patent. And other than natural person, startup, newly startup companies or any small entities like small group of people or any other educational institutions or companies can apply for patent. So in this, for startup companies, there are certain criteria. The company age should not be more than 10 years from the date of incorporation. And company type should be the private limited or registered partnership firm or a limited liability partnership. And their annual turnover should not exceed 100 crores in any financial years since the incorporation and original entity. The company should be formed by originally, not any split up of from larger company or not any sister companies. And always that company should work for the development and improvement of a product and also along with the creation of wealth and employment. So these are the different forms required for filing the patent. Form 1, 2, 3, and 18A and 18 and 18A for a request for examination. Form 5, 9, and 26. Let's see in detail what is. This is the form 1. Here we'll be giving details about the patent, like details about applicant, inventor, title of the invention, any convention country, in the sense if the same person is applying patent in different countries and along with the native country, then in the field of convention country, the details need to be filled. And also declaration by the inventor and declaration by the inventor need to be given, this form 1. And these are the different types of declarations they have to give. Going on to form 2, here this is the provisional or complete specification. Let's see what are provisional and complete specification in coming slides. Here, this is how the form 2 looks. And also the different types of claims need to be given in this 5th section here, along with the title of invention. And this is the form 3. Here, the details of statement and undertaking, along with the foreign details. If the patent is filed in other countries, those all details also need to be given here. And next is form 5. This is the declaration as to inventorship. The inventor, whoever is filled in the form 1, have to give declaration that he himself have designed this idea and want to file for a patent. The declaration need to be given in this form. And these are different types of patents, patent applications. So ordinary application is of 2 types, provisional specification and complete specification. So provisional specification means in this, if whenever the idea comes to brain, you can file for the invention and you have to wait for 12 months so that you can file it, convert this provisional specification into the complete specification. Complete specification requires all these details about the patent. In the complete specification form is form 2. Field of invention, background of invention, prior art, advantages of prior art, summary of invention, statement of invention, all these need to be given. But on one condition, that it should not exceed the 30 pages and claims should be less than 10. If they are more than that count, they are chargeable. And another one is convention application. In this, if the patent applicant is filing the application prior to the date in other country, other than native country. If we are, for example, if we are Indians, we want to file an Indian patent. And along with that, you want to file a patent in Japan also. First, you need to file the patent in Japan and you need to give that specified date and specified information in Indian application. That type of application is called as convention application. And after filing there, you can file this convention application within 12 months in India. And next is PCT. That is a Patent Cooperation Treaty, national phase and international phase. 2 phases are there in this. And the international phases means same as a convention application, filing the application in internationally in other countries other than native country. And the national phase is same like convention. It's you are filing you are converting the international application into the national. national phase. That has to be done within the 31 months from the international filing, or earlier also you can do that. And next is patent edition type, application type. In this patent edition type, sometimes the patent or inventor is having a more number of information, or might be the changes in the whatever the application they have filed. So they can file for this patent edition. They can give the what we call supplementary information in this edition application. And divisional application, if the application is a more number or claims are more than given number in the application form, then we can divide this application into 2 or more applications. That type of division is called as divisional application. And next is request for examination. If we won't request for the examination, then their patent will not be granted. For that, to request for examination, we need to file Form 18. And Form 18A is to expedite the examination. This 18A can be filed by startups, companies, or international patent searching agencies. They can be filed for this 18A form. And next one is grounds for opposition. Who can, like, on what basis the patent can be opposed or rejected? So if the applicant has obtained the information wrongfully from like copied from any other invention, or any prior publication has been done but not informed to the patent authority, or prior claiming, and if the and next obvious, like if whatever the invention you have made is not having any inventive step or new things, then obviously it can be rejected. And non-patentable things are described by the patent authority under Section 3 and 4 Patents Act. So based on that, non-patentable acts, if we try to file non-patentable things, then they can reject it. And insufficiency of description, whatever the application we are filing, if in whatever the application we are filing, if the application is incomplete or insufficient, then that can be rejected. And if we are failing to disclose any foreign application, like for example, if the same type of patent has been patented in foreign countries, if we are not giving information about that in our application, then based on that also they can be rejected. And also, if we fail to convert the provisional application into the complete application within 12 months, then also it can be rejected. And if we cross the timeline, then also can be rejected. If and any anticipation invention with traditional knowledge, I mean, if you are using any traditional knowledge and trying to copy that, then also it can be rejected. And filing procedure can be done in 2 ways. One is a physical way and online way. In physical way, we can do it directly through the post, or directly we can go to the office. Here we cannot use the help of any patent agents. But in the online filing, we can take the help of any patent agents. Here is the link of that application portal. And this is how the patent e-filing application looks. And here in the comprehensive e-filing, we have to go and we have to create an account in the database on our name, or at least on applicant name or inventor name. Then we can proceed for filing. So these are the different offices, as earlier Madam told, Srikala Madam. But these offices are also can be claimed as a territorial jurisdiction. In case of any patent threats or copyright theft or is happening, then we can approach these jurisdictions to file any complaint or case on behalf of inventor or applicant, or directly can go and file a case. And these are the different phases for the different forms. For form 1, if we are educational institute or startup or a small entity, we can, that is 1600. If other than that, if any manufacturing company or any bigger companies who crossed a turnover of 100 crores per year, then they have to file for 8,000 rupees. And form 2, within the prescribed limit, we can file, it's free. If the prescribed limit has been crossed, then we have to pay fees. And for form 3, there is no fees. For form 9, that is 2,750 for educational institutions and 10,000 for others. And form 18 also 4,000 for small startups or educational institutions. And for others, it's 20,000. So this is how the patent application process looks. once we file, we need to ask them for the publication, which will happen with the first 18 months of the filing. And we need to request them for examination using the form 18 and 18A if we want any faster the process. That will happen within 48 months of the publication. And once the patent is examined, they will give the report based on that. So, and they'll give the response to us. If we have the applicant or inventor has to refile that, and they have to clear all the objections raised by the patent authority, and we have to file, and that will be discussed again in the patent authority office or jurisdiction office, and they'll grant and they'll notify us. If there are two types of oppositions: pre-grant, before the request for examination itself, they can refuse our application, or and post-grant, that is after the granting also. Sometimes if other countries are having same applicant and we haven't disclosed that information, they have a chance to reject that application. So if we in sometimes once after reapplying also, they'll ask for further examination of report. So that will take for 12 months. And again, after hearing, and it will be grant or refused, that will be the decision will be based on the patent authority. And this is the examination procedure. First examination is of two types: formal examination and technical examination. In formal examination, we will be giving the basic details like application name, what is the inventor name, like basic details will be scrutiny. And in technical examination or substantive examination, they will search for the state of the art. That means if the patent is having any international, if the patent is have been published anywhere in other countries, or any other is have been withdrawn upon this. So those all will be cross-checked. That is substantive examination, or also called as technical examination. And the first examination report will consist of different types of objections, which are communicated directly to the applicant. And next, then once they give all the objections to the applicant, they have to check, reapply that, and they'll re-examine, and they'll clarify all the objections they have raised. Once, sometimes here they may ask for further examination also for further second hearing, or else if everything is fine, then they will go for the hearing, whether to grant or refuse the patent. Here, these are the basic timelines for provisional to come from filing provisional application to convert it into complete application. It takes 12 months time. For request for examination, it takes 48 months you have to wait, and within the 48 months you have to file for request for examination. And to reply to the whatever the responses they have given, that will to reply to that, it should be like within 6 months. To file form 3, we need 6 months. For form 5, 1 month. Withdrawal application, 15 months. Once we file the patent, once it is published, after that we have a chance to withdraw our application, which can be done within 15 months of after that. And hearing the submission, they'll take 15 days for hearing that. And pre-grant, before the request for examination itself, they have a chance to reject that. And post-grant, that will take for 1 year. And as of now, Nirmala College of Pharmacy have applied more than 43 patents, in which 2 are granted. One is for the polyherbal formulation for psoriasis, which and the inventor for that is Dr. Anjana Madam. And second patent is by title is bodily medical design patent, that is design design of a medical device which can detect the bodily fluids in the neonates, for which inventor is Dr. Vinay Kumar sir and other colleagues of Nirmala College of Pharmacy. And totally 38 patents are published on behalf of Nirmala College of Pharmacy. I thank everyone for giving me this opportunity.
Thank you, madam. Thank you very much, madam. So, Satyasri, madam, are you there, madam?
Yes, sir. Hello, sir. Hello. Hello, sir.
Yes. The vote of thanks, madam.
Okay, sir.
Okay.
Okay, sir. Good afternoon, everyone. Especially good afternoon to the Rahman sir, faculty members, guest speakers, and other participants. Under Mentor-Mentee program is introduced by an MHRD Innovation Cell. In this regard, we opted Nirmala College of Pharmacy as a mentor institute. Under this Mentor-Mentee program, today we organized a guest lecture on importance of IPR in research in association with Nirmala College of Pharmacy. I thank guest speakers as well as innovation ambassadors of today's section, Mrs. Sri Kala ma'am and Dr. Shriya ma'am, for delivering a lecture on the importance of IPR and what are the types of patent applications in elaborated manner. I thank you, both of you. And finally, I extend my thanks on behalf of our principal sir, Dr. A. Lakshman Rao Garu, and on behalf of Viva Institute of Pharmaceutical Sciences. And I thank Rahman sir and other organizing members for accepting our invitation as a mentee and organizing a lecture on importance of IPR. Once again, on my own behalf, thank you, sir, Pamal Reddy sir and Rahman sir and other organizing members of Nirmala College of Pharmacy. Thank you, sir.
Yes, madam. Thank you, madam. Thank you very much.
Thank you, sir.
Welcome. Thank you. Thank you, all the participants.
Okay, sir.
అది ఇంకా కట్ అయిపోయి